Shall we start? Okay. Uh, Good afternoon, all of you, and thank you for joining us in this live session. This is the first live session for the course Patent Law for Engineers and Scientists. This is a course that we launched in 2017, and almost every year we have been running it. And we do have quite a lot of diverse students, sometimes professors, sometimes professionals, joining this course and doing it as a part of their NPTEL-NOC's ambitions and aspirations. Now, what this course is particularly tuned for, it is already mentioned in the description, but I should reiterate it again. This course is particularly tuned for cracking the patent agent exam. The patent agent exam is an exam that is conducted by the central government. It is conducted by the Indian Intellectual Property Office. And this course, along with another course, which is patent drafting for beginners. Normally, we launch these courses together so that people get the benefit of taking the exam. And these two courses are mapped towards paper one and paper two. This course is mapped towards paper one of the exam. And the other course, patent drafting for beginners, is mapped towards cracking or clearing paper two of the patent agent exam. The patent agent exam has now been conducted with a fair amount of regularity. I would say that almost every year you can expect it. In some years, they've conducted it twice. Today, the number of patent agents that are there on the register, it comes to something close to 6,100 or 6,200 registered patent agents. Some of them may not be practicing. Some of them would have quit practice. Some of them would not be in the scene at all. So roughly you can expect, and we don't have at least I don't have the data of how many active practitioners are there. So largely we are looking at something between 4,000 to 5,000, roughly. I mean, that's the number of patent agents that are there. Now, is this a course only for the patent agent exam? The short answer is no, because you could clear the patent agent exam taking these courses, but it also gives you a introduction to, and I would say a deep introduction to patent law. If you do any of the PG diploma courses on patent law, I mean, there are many PG diploma courses which will give you a certificate at the end. I'm not sure whether they would do it at this with this intensity, because we actually go through a section by section analysis, which not only helps you to understand the law if you are interested in becoming a patent agent, but it also gives you a broad overview of what the domain is. So this course, that is Patent Law for Engineers and Scientists, is tuned to be a part of the course along with the patent drafting for beginners. So I've seen the pattern in the last few years. It could be, okay, there are some questions coming up. I'll take them up. Please take the questions from Zoom and post it onto the document. I'm just going to share the document so everybody can have a view at it. Now, this is the document. So please post the questions here so that I can take them up as they come up. So I may not be watching the Zoom chat. It's difficult for me to keep an eye on that. So Ekta or somebody who is there, please cut and paste them here. Okay. Now coming back to the pattern has been that the people who take this course also tend to take the patent drafting for beginners course. Okay, so there is a overlap there in the sense that people who want to take the exam. The exam is, by the way, it is coming in Jan 2026. The next patent agent exam is notified to happen in January 2026. So I'll just briefly, there may be some overlap because for the benefit of students who want to who could not have. By the way, we don't have a live session for a 4-week course. This being a 12-week course, we can have it. So I will just give you a quick answer to the possible queries that could come when you are doing the patent drafting for beginners course. As we have mentioned, drafting for beginners means that you are literally looking at a beginners course in drafting. It's not meant to be an in-depth course. And drafting, like any other course on writing, it's a course on writing, needs quite a lot of practice and you need to do quite a lot of assignments and exercises. We do give you some exercises, but that's not enough. We know that in 4 weeks, you cannot simply teach drafting in great depth. Now, a couple of pointers for people who want to excel in drafting is that I'll just give you in an order. So keep this in mind. The first thing is you will be very tempted to use AI tools that are available today, both the generic tools like ChatGPT or Perplexity or Claude or anything that you have been using. But let me tell you that drafting has to be learned the hard way. So, and in the exam, you will not be allowed to use any of these tools. So don't get into the temptation of using AI tools early in your career, where you have to put pencil to paper or fingers to typewriter or to your keyboard and actually do the work. This I say because from my experience, the people who excel in using AI today in patent drafting are the people who have very sound foundation in drafting. They use AI tool as a companion, as an editor, more than creating the first draft using the tool itself. So the big difference is there. So I'll come down to that at a later point if time permits. So the first thing is not to use the tools while you are learning it. Okay. And the second thing is to the essence of writing well is to read quite a bit. So unless you are reading what you plan to write on, in your case, you want to draft patent specifications from a blank page. You have to be reading quite a lot of patent specifications that are already there. Now, I've repeatedly mentioned this. It's easy to find out who are the big players in this field. Now, you can just do a Google search and find out, or an AI-enabled search in this time. You could do that and find out who are the leading filers of patents in different streams of technology. So if you have a biotech background, you can find out who are the leading filers of patents in biotechnology, who are the leading filers of patents in electronics, communication, automotive. You will find a list of top companies who are actually doing the filing. I mean, for instance, motorcycles, you will find Honda. Honda is a Japanese company which has filed quite a lot of patents. Now, if you are interested in, if that is your domain, automotive and two-wheelers, then you would be reading the patents of Honda, the way in which they are drafted, and they're all easily accessible. So unless you read quite a bit, you are not going to get to a point where you can write good patents. So the amount of reading you do has an impact, and it's a direct impact on the quality of your writing. So you would be doing that, and slowly you would be doing exercises, and it's not hard to do exercises. If you just take a patent specification of Honda, for instance, you can just ask your friend or some colleague to cover the title, and you read the specification and you come up with a title. This is one of the questions that you would be facing in the exam. Or ask them to show you a specification without the abstract, ask them to hide the abstract, and you create the abstract, and then you can compare it. Similarly, you can look into a patent specification, ask your friend or your colleague to cover the claims, delete the claims, and then you read the complete specification and you draft the claims in the light of what is there. Now, all these are exercises that you can do, and all these will expose you to how things are being done. And obviously, you have the benefit of you can check it on your own, or you ask your friend or your colleague to check it. Now, these are simple things that can make your drafting better. And I feel that because we didn't have an opportunity to discuss drafting in a live session, I'm just putting this on here. The recording will be available, so people can just look into it and see that what are the few things that they need to do to get better at drafting. I would say that don't rely on early AI tools early in your career. You need to do the drafting on your own, whether it's writing on paper or on a screen or in whatever way that is. You have to do that. Read quite a bit. I would say that you should be reading, if your time permits, at least 5 specifications in your domain, reading them, understanding them, how the brief description of drawing is written, how the technical field of invention is mentioned. There are all lessons to be learned here. Then if you look at the background of invention, where the technical field is mentioned, you can just see that the sentences are, there's a very broad sentence on what the technical field is. Then there is a much narrower sentence, and there is a much narrower sentence. Most of the time, if it is a very well drafted patent, you can actually see the first broad field is actually a classification in the IPC or the CPC, which are patent classification codes. And then you will see a subclass and a subclass, and they introduce you to the the domain in which the invention sits. Now, if you have, I mean, if you have done the course, you would have seen that we do mention CPC and IPC codes, how they are relevant for categorizing the invention. So you will see this. You will be able to map this on your own. And today, there are many tools that are available which you can use to come up to speed with some of the developments that are happening. So the first thing is, don't rely on AI tools early in your career. AI tools are best a tool for assistance and editing, and use them once you have learned the foundation of the field. I mean, even if you look at the top fiction and non-fiction writers who were pre-AI, in the sense that they were best-selling writers before ChatGPT, and they continue to be best-selling writers. And they are quite open about the model in which they work. They may use AI for research or for brainstorming or for even editing, but they hardly use it for writing, because that's a lesson to be learned. And you could still, so the thought, I mean, if you have been following the debate on AI will definitely replace mediocre human work. There's no doubt about it. Mediocre human work will be replaced by AI. But top-notch human work, which comes from years of experience, is unlikely to be replaced by AI. That's what we are seeing right now, and let's hope this will continue. Okay, so that's the small bit on pattern drafting. Don't use AI early in your stage of getting to know the nitty-gritties of the field. Do read quite a bit in the area of your interest. If you have a domain expertise, start reading in that areas. Read patent specifications. Then third, do some exercises by covering up parts of it, which I just mentioned. Cover up the claims. Ask your friend to do that on a PDF and draft the claims and check it, or ask your friend to check it. This is how you're going to be doing. You are going to be drafting it on your own. You're going to be reading quite a bit, and you're going to get feedback based on some exercise you did, so that you can correct yourself. Okay, that's the quick thing on patent drafting. Now, patent law for engineers, we are still midway in the course. We still have a few more weeks to go, and if we are, obviously, my team is there. We are answering all the questions on the forum to the extent possible. And if we miss out something, I mean, the NPTEL team is there to remind us, and we try to do the best that we can on that. Now, one of the things that people normally ask me is on some extra training or something beyond the course. And for that, we have launched, I've launched what is called the Bulletproof Patents. If you can just see here. Now, this is a newsletter, free newsletter, and it'll remain free. And newsletter for people who want to follow some of the developments on patent law. Now, if you click on it, you'll see that now that's and one-to-one I had with one of the practitioners. So I just cut the audio file and I post it here so that people can follow it. And there are some case law analysis. You can see this. This is the case law analysis. And so on. So this is one free tool which will keep you. And there's also bulletproof designs, which is we are just developing that, because today the patent agent exam, 20% of patent agent exam is designs, literally. So we need to cover that as well. So coming back to this, let me just now start taking the questions. If there are more questions, please feel free to raise them in the chat here, or if you are watching us live on YouTube live, then please post the questions on chat. I hope somebody from the NPTEL team or in our team is looking at the YouTube live as well to see whether the questions are being posted there, and please reproduce them here. I'll try to answer them in the order in which it is posted. So we have a question here. I will just rather cover this up so that, okay, and the mobile number here. Okay. Okay, so the student name is fine. Okay. Okay, so the question is, I'm trying to crack the patent agent exam. Could you please train me personally? That's it becomes hard for me to do such a thing, because this is a mock, as you know. This is a course that is meant for a larger audience. I really do not know whether it will be possible to train people personally. I'm sorry about that. How to memorize forms and what is the relevant rules and section. We have a specific video on memorization. If you see that the forms video, the fees and the forms, I think there is a video. If you have already covered that, you will see that the key memorization technique, I would say, will be to look at the index to the forms. Just before the forms begin, there is an index to the form. I think 30 odd, 32 odd forms are mentioned now. And try to relate, you have to just memorize it as something that normally that happens in the course of an application's life. Okay, in the course of an application's life, somebody files an application, and suddenly you want to change the details of the applicant. How do you change the details of the applicant? But there has been an assignment. So there's a form for assignment. So you see that and see, always ask yourself, what purpose does this form serve? Understand the purpose, then map it to a section and map the form together. For instance, there is an opposition that is filed. It's a pre-grant opposition. And you know that there are two kinds of opposition, pre and post. Now, pre-grant opposition, how do I file a pre-grant opposition? So there is a section for it. Now, post-grant opposition, there is a notice for post-grant opposition. There is a form for it. I want to file an application for compulsory license. There is a form for that. So what you need to do it, and we already have an video on the life of a patent, and we say that the act is actually mapped onto the life of a patent. It starts with application, it goes through prosecution, it gets granted, and there could be some other stuff happening like compulsory licensing or licensing and infringement, all that. So you can trace the act, the structure of the act to the life of a patent. Similarly, when you go to the index, and the index is like, I can just pull this up fully. Okay, I'll just okay. Can you see the Bar Act here? Is the Bar Act visible, or should I share a screen now? Can you see my screen? Is the Patent Bar Act visible on the screen? Can somebody comment on the?
No, sir, it's not visible.
Okay, sorry. Then I need to share the screen fully. Hold on. Yeah, thank you. Okay, is the Bar Act visible now? Yeah, okay. So this is what I was mentioning. This is the list of forms. Okay. The list of forms, it gives you the sections and the rule, and it also gives you the title to the forms. Now, this is how you will and there are, you can see that there are 31 forms. And this is how, and if you look at it, it is actually mapped to the life of a patent. So you would ask, okay, amendment to the patent, and what time does the amendment come? Does it come before or after? Okay, this is actually the amendment to certain details in the patent. Amendment to the patent itself is a different form. I mean, we deal with this in extensive detail in our videos. So you would use the second schedule to come up to understand how these things are related. Always when you take a form, look into the form and ask yourself what purpose this is serve. And at the top of the form, you will find the relevant rule and the section, so you understand what purpose it serves. So once you understand the purpose, as I said, there are two amendments. People can get confused here. Okay, here is an application to amend of patent, and here is an application to amend a patent and a complete specification. So these two serves, this 57 is a general amendment, and 44 is some details with regard to a patent. So you will understand the difference. Okay. Where is the next question? Okay. So memorizing forms, you use the schedule 2 and make a relationship with it, and you will get it. You will get it once you look into it. But you will have to always ask this: what purpose does this form serve? Once you understand that, you can place it in the lifeline of a patent. And the lifeline of a patent, I've mentioned it, mimics the lifeline of the act and the rules. The act is actually structured like the lifeline of a patent. So now you can draw your own memorization tool and say that this is where form 1 comes in, form 2 comes in. They all come in at the early stage. And form 3, form 4, now you can draw a timeline and try to memorize that. Hope that answers the question. As per Patents Act, are patents classified as design or utility patents? So utility patent and design patent are terminologies used in the US. We don't use that. We just say a patent. and we call the other thing, which they call design patents, we call them designs or industrial designs under the Designs Act 2000. So, okay. So this is the thing. Till last year also, or till 2024, we didn't have designs as a part of patents. Now the patent agent exam, 20% of the marks come from designs. So somebody who is keen on that would want to study patent, the designs as well. So in our Patents Act, we follow only patents, which is the equivalent, the US equivalent is the utility patents. So all the patents, it's a 20-year term patent, whereas the industrial design has a much smaller term. And the industrial designs are actually the right that covers aesthetic aspects of a technology or of a product. The aesthetic part. It does follow the functional part because the functional part will be covered under the Patents Act. So that you need to understand the difference between a utility patent. Utility patent is an American terminology used for the patents granted under the Indian Patents Act. That's the equivalent there. The design patents, the Indian equivalent is what we call industrial design, what comes under the Designs Act 2000. That's it. So difference between these two things. In patents, we cover technology, the functional aspect of technology. In designs, we follow the aesthetic or what appeals to the eye, not the function, Okay, that's a short description answer to that query. Is it necessary to go through IPAB and its rules and sections? No. As I said, this course was launched in 2017 as a live course, which got recorded. So at that point, IPAB was not there. We still left it for historical purposes. Somebody who's interested can just go back and see it. But in our early interaction with you, we would have shared with you the changes. I mean, if you see the forum, the changes that have happened over a period of time, and there is a post on that, and you can look into that to see how the laws evolved over a period of time. IPAB, there won't be any questions from our end. We'll try our best, and there won't be any questions from the IPAB from the on the patent agent exam as well, because that is moved. Now it has been replaced by the commercial codes. The IPAB has been abolished. Now, are there any inventions that cannot be patented? Yes. The long list runs in section 3. If you read section 3, it lists what are not patentable inventions, a long list of things. Now, the long list, I mean, if you watch the video on it, I mentioned that they fall under 4 or 5 categories. One is things that are protected under other IP acts, may not be protected by patents. For instance, some aspect is protected by copyright, is not covered here. The topography of integrated circuits is covered by the Semiconductor Topography Act. It's not protected under the patents. Matters that are covered under trademarks per se cannot be protected here. So things that are covered by other IP is not protected under the Patents Act. Things that are against public policy. So you may have an excellent invention. Say the classic example that we use is the guillotine, which was used for beheading people in Europe during the Dark Ages. Though if somebody may come up with that invention because it involves killing human beings, it's against public policy. We may not grant that. Things that are inventions that are that develop on, say, mathematical equations or business methods. You have a long list of things under Section 3. So what qualifies as an invention, for instance, in US, a business method patent is an invention and they grant it. Or in some other jurisdictions, they may grant, say, a genetically modified animal. In India, we don't grant those things. So there is a long list of inventions which may qualify for inventions in other jurisdictions, but Indian Patents Act does not grant it. Can we expect defined drafting questions like the one with patent drafting? Good question. Now you have to pick up the question paper 2025 patent agent question paper, that is this year's question paper, and see whether there were any drafting questions on design. My memory is that there were some questions. Let me think over it. Paper 2, I'm not sure. I checked paper 1. There were some questions, but not on drafting. But you have to check that. I've not done the checking myself. Ekta, if somebody is here now who is aware of it, can you just look into it so that we can answer that whether the patent drafting, the paper 2 had any drafting questions? But design is difficult because in design you don't draft. This is one thing to understand. You don't draft. You just show the description of the design, which is largely a drawing. And I'm not sure whether they will ask you to, because the drawing is not a part of our paper two at all. If you look at the structure of paper two, which is the drafting paper under the patent agent examination, there is no question asked on drawing because it'll be very hard for you to draw without the tools. And design is nothing but drawing with a very light description. So I do not think there will be any questions in paper two, but we could check that. And if you raise that question in the forum so that we don't miss out, we will be more than happy to answer you. We will look into paper 2025 paper two and see whether design. My understanding is that it would not be the case. We need more case studies about infringement and compulsory licensing. Oh, infringement and compulsory licensing. I mean, as I said, the key objective of this course was to help. I mean, we mentioned it plain and clear right up front, is to make you crack the patent agent exam. And the patent agent exam largely focuses on matters that happen within the patent office, which is up until grant. And yes, compulsory licensing, there are a few cases there. Again, as I said, you could follow this Bulletproof Patents, the newsletter, and when the new cases come on infringement and on compulsory license, there will be some updates on it. So that will be a good way to do that. This would require, okay, there's another part to this. Infringement and compulsory licensing are things that normally happen after the grant of the patent. Though compulsory licensing happens within the patent office, infringement does not. It's in the court. And that would require us to have a different set of kind of a course. I've been contemplating on that, whether there will be, it's like an advanced patent law course now that we have these basic courses there. And based on it, we'll try to do some kind of a survey. If there is interest, probably we can launch that infringement and compulsory licensing course as well. It'll be patent enforcement or advanced patent law. It'll be on the enforcement aspects, which we don't concentrate on this case in this course at all. What will be the pattern of NPTEL exam in October 2025? The pattern, though, yes.
Excuse me.
Yeah. Go ahead.
Sorry to interrupt you, sir. Am I audible?
Yeah, I'm audible. Go ahead,
Sir?
Go ahead. Yeah, I
Sir,
can.
actually, we are preparing in some way. Paper is in different way. Actually,
Your voice is breaking. Can you come again?
the question paper, our preparation is. Sir, am I audible now?
No, now it's clear. Go ahead.
Am I audible now, sir?
Yeah, it is clear. It is clear. Go ahead. I can hear you. Yeah.
Sir, our preparation is. Yeah, our preparation is full and full based on the sections, forms, fees, everything. But in the question paper, by seeing the case are getting confused where to refer all these things, like that is the thing. Which website, patent office journal have you to refer or what?
Okay.
That is the thing, sir. Because I'm applying this already 3 times I attended this exam. Every time expecting to fail. 4th time also appearing. That is why he's fortunate.
Okay. So what you will do? I mean,
I had a chance to find a solution to get clear.
Okay. If I'm in your position, if I have 3 times, I've attempted the exam 3 times. By the way, it's not a bad thing to attend it 3 times. I know people who attended it multiple times and then they topped it. Literally topped it, because what you have to do is you have to reverse engineer your experience in the last 3 attempts. You have to look into the question papers, what you got right and you got wrong, and you have to now create reverse engineer in the sense that look into the question papers and look into what are the areas in which you were weak and try to enhance your capabilities there. If my understanding is right, there are not much questions that come on infringement. There may be a couple of few questions, but largely the patent office focuses on the things that happen within its domain, which is like filing the application up until grant. And this is the main focus of it. Now, if you find that once you do this reverse engineering, you take the question paper and find where you went wrong, then you will be able to take all the questions and categorize them under those chapters. The Patent Act and the patent rules are in different chapters. And now you will get a very good idea about where your weakness is, in which areas you need to understand more. And see whether these questions were questions that you could not have anticipated, in the sense that you saw the videos, you read the act, you read the manual. Manual is another important, the manual of patent practice, which is available at the Patent Office website. That's an important tool for you to understand. Now you would read that, and then you will fill your gap. Literally, you fill your gap. And I would say that if you have taken the exam 3 times, you will have a fairly good understanding of the kind of questions that that are coming, the kind of pattern that gets repeated. And I would just say that be strong on your fundamentals, like what priority is, what the examination timelines are, how expedited examination is done. And once you get into the details, and for that you will have to understand in some detail on how this is being done. Okay, so I would, in your position, I will go back. I will try to see where were the weak. For each person, it's going to be different. And because you had 3 attempts in your thing, I would say that you have to really reverse engineer and understand where your weak areas were and strengthen them. Is that clear, Bhuvaneshwari? Yeah, please do that. And it just takes a weekend for you to
Now
do
I
that.
got clear. Thank you, sir.
All the very best to you. And see, now just you need a weekend to do this. You need a weekend to do this and spend more time in areas in which you are weak. Watch the videos, read the sections, and look into the manual. I think you will be good this time, hopefully. Yeah. Okay. So any other questions, you can just stop me and
Thank
ask.
you, sir. Thank you.
Yeah, welcome. All the very best. So if there are any questions, you guys can just stop me and ask me. I'm just going with the list now. So infringement and compulsory licensing will require a different course, and I've done this. Long ago I've conducted a seminar course. I taught a seminar course in National Law School. I graduated from National Law School with my master's some time ago. So I went back and taught a course there. It was called the Advanced Patent Law. So this requires a different course. We can't fit it into this course. At best, I mean, I was thinking of fitting designs into this course, a short form of design, so that, this course becomes self-contained. But then we may have to rename this as Patent and Design Law for engineers and scientists. Anyway, I have to get in touch with the NPTEL team to understand how much leeway we have. I think we already have 25 hours of lectures or 27 hours of lectures. So they have this maximum cap. Anyway, that's one option. Launching a design course in itself, you don't need a 12-hour course for it, maybe a 4-hour course. I mean, these are things we are exploring. And if somebody is interested in assisting with us or collaborating with us or in giving their thoughts and ideas and reflections, will be more than welcome. Please use the forum, or you can just get in touch with me through LinkedIn, or there are multiple ways in which people can get in touch with me. Yeah. So then let us look at the next question. What would be the pattern? A pattern for the NPTEL exam has been, it's there. I mean, I'm not sure whether we have circulated that in the forum. Please ask that question. We'll just show that we will disclose the pattern to you. We kind of the patent. This is largely a multiple choice exam, and we try to mimic the patent agent exam in the pattern. So that's what we have been trying to do over the years. So it will be multiple choice questions, and if you're really thorough with it, you can really finish it off really fast. In fact, I know people who just finish it off in half an hour, sometimes 45 minutes. But some questions require you to deliberate and complete it. So, and there are people who take the full time as well, because you have to apply your mind on things. Okay. Do we need to mug up all section, subsection numbers? No, we don't ask such questions. We don't ask what is section 21. We don't ask that kind of question. We are here to test your understanding on it. The patent agent exam may sometimes have a cross reference to a section, but we don't do that. We try our best not to do that. In fact, even if we ask you a question, probably if you read it clearly, you will know that it has something to do with something, a connected theme. So we try to avoid questions on directly asking you on what is Form 7A, or we don't do that. That's not the object of this setup. Hello, sir. It would be helpful for all students, if possible, to explain patent licensing. There is a video for this. Please watch it. The life of a patent. You will find that in the material that we have done. It should be in one of the earlier videos. And if you post the question on the forum, we can actually direct you to that video. Okay. How reliable is for revision? Okay. Reliability of ChatGPT, I cannot vouch because each time you ask the same questions twice, you're going to get two different answers. So I cannot vouch for ChatGPT's reliability, but I can tell you that the paid version, which is the $20 version, which is what ChatGPT thinking. If you use the ChatGPT 5 thinking, it takes some time to give you the answers, but then you can go back and verify this. So you can use all these. These are modern tools that you have. I will not discourage anybody from not using these tools. But if you want a closed environment answer, then what I would do is if you have access to old question papers from the patent office, I will upload all the question papers on Notebook LM, which is a closed environment, and then ask subject-wise questions. I say I have uploaded all the 10 or 15 question papers that are there in the public domain. Then I will say that, and I've just finished my revision on priority, for instance. I've seen the video on priority. I've understood. I've done a few questions on priority. I've read the material, the section 11 and all that on priority, and I'm fairly good in my understanding on priority. Now, I will create this data set of 15 odd or 10 or 15 odd question papers, past question papers, then ask Notebook LM, post me all the questions on priority with their choices. So it'll start doing that. You can start answering it. And you can also post the key. The key is also available publicly. You can see that, the key to the question. And then you can ask it to correct it. And then you can go back and verify it. So this is how I would do it if you are wary of using ChatGPT, because ChatGPT is completely connected and but you need a close environment to do revision. So I would strongly urge Notebook LM over ChatGPT. Hope that answers that question. Where is the next question? Okay. Some good books on IPR. See, IPR is a very broad term. If you're looking at patents per se, then there are new books that are there. Like Pratibha Singh's book is a new book. I've not read it myself. Then Adarsh Ramanujam is a patent agent, come a lawyer. He has his book. Now, these are the new books in the market. I've read Adarsh Ramanujam's book. It is a book that covers quite a bit, and I'd also reviewed it once. So, but it's not tuned for a patent agent's examination. And Sheetal Chopra has a book on patent agent exam. These are some of the big books that you will find in the market. So if you're looking at, I would say that go for something that is new, latest, in the sense that, and my book is quite old. I don't even recommend it. It's 17 years old, but I'm preparing the update, but I will not recommend that. It's quite old. So go for a reputed author, like a retired judge or a sitting judge, or somebody who has been practicing, a practicing agent or a patent agent who is reputed, and also look for something that is current. Don't invest in a book, because in the last 5 years, there have been multiple amendments. IPAB has been abolished. There have been quite a lot of amendments to the rules. So I would want you to invest your money to get something that is current. So that will be my advice on the books. Okay. Any other questions? Anybody wants to share some thoughts, wants to come online? Okay, so what we will do, there is if there are no further questions, you always have the course is still running, so you will always have the option of raising the questions in the forum, and we will answer that for you, and we will. Let me just take that, and there's one question that is there, so probably maybe I can do something given the time that we have. Hold on. So there is some time. So let's just try to do this. I'm just trying to open something for you. Okay, let me just share my screen again. Because we had that question, I would just want to. Okay, can you see my? Okay, so this is for the person who asked the question on the life cycle of a patent. Okay, so let me just try to bring this to you. So this is the video that we already have in the plane, but let us just look at this as the lifeline of a. It's not a straight line. Sorry about that. Hold on. Okay, I just okay. Now, if you look at the lifeline of a patent, now there is a starting point and there is an ending point. Okay. Now the ending point and this, sorry. Now this is the 20-year life of a patent. This is a 20-year life. It starts with time of application. TA is time of application. So the time of application. So the patent life starts with the time of application and it ends with the time of expiry. TE is the time of expiry. Time of expiry. Now, the time of expiry is quite flexible. It doesn't mean that all patents will see 20-year time during their life, because in some cases, the patent can get revoked. So if the patent gets revoked at this point, then TR is the time of revocation. Time of revocation. So which means the patent had a shorter life. In some cases, it will be less than. So 20 years is the maximum. Now, if you draw a dotted line here, somewhere here, okay. Okay, this, okay. Now, this could be the place where the grant happens, time for grant. Most likely, time of grant. Most likely 2 to 3 years or 3 to 5 years, depending on the technology. Now, all these things to the left of the dotted line happens at the patent office or the IP office. Okay. And most of the things, not all the things, happens in the courts. Okay. Some of the things happens in the patent office as well, like for instance, compulsory licensing. Okay. Those are the things that though they are things that happen after the grant, they happen within the patent office. Now this is the life of a patent. Now this, all of you will understand that there's a 20-year life starting with time of application till the expiry, and there's a grant in between. Now, if you now look at the sections, okay, if you look at sections 1 to 6, okay, largely 1 to 6 is on the initial part. Then 6, they talk about applicants who can apply. Then they slowly move into application, the form of application. Then this, so you can look at it up until the section 50 or so, or 50s. I will say in the 50s, section 50s are things that happen here in the patent office. And similarly, you can do a mapping for the rules. And beyond 50 up until 140, 144 or whatever, 146 or whatever, 140s are things that happen in the courts or after the grant. We will say after the grant because there are some things that happen before the in the patent office, but after the grant. As I said, compulsory license. You can see that compulsory license, something happens after the grant. So now this is the scheme that you will have in your mind while you are preparing. So if you look at the timeline is mapped. This is what I said. The timeline is mapped on the life of a patent. Life of a patent starts from TA, time of application, and it ends with TE, time of expiry, which is normally 20 years if it is not revoked. And TG is a flexible timeline. It can, there are cases where in 8 months, 10 months, it gets granted. There are cases it takes 3 to 5 years. There are cases it takes even longer if there is a pre-grant opposition and things get dragged. So this is what we had to tell you about timeline. So that's because you asked that question, but believe me, there is a video for this. If you can raise this in the in the group, probably in the forum, we can even link you to the video. Okay, that's it. So if you are interested in understanding more beyond the course and latest developments, subscribe to this newsletter. Just Google Bulletproof Patents and it'll take you there. It's a Substack newsletter. So things will get directly delivered into your email whenever there is an update. Yeah. So I don't think there are any more questions. So if everything is fine, then we can conclude this session. Is there anything further? Any clarifications required? Okay, the book related to patent agent exam, I've already shared. You go by there are multiple books on patent law, and there is one book that I know by Sheetal Chopra, but you need to see how often it is updated. And if it is an updated book with all the things, you can go for it. In my experience, we have been running this course since 2017. And the book is the Bar Act. Let me be very blunt with you on that. There is no book that you need for a patent agent exam. Yeah, IPR, yes, it's a different story. Patents, yes, it's a different story. But if it's just the patent agent exam, you just need the Bar Act and our courses. There are hundreds. I don't know. It could be. I recently heard it could be even in thousands. There are lots and lots of people who have cracked the patent exam just with this course and the Bar Act. So I would say that just by doing this, you should be able to do that as the people in the past have done it. Okay. Oh, then. Will videos be available until the conclusion of PAE and further? I don't know. See, YouTube works in different ways. I still have access to very, very old videos. You should be able to do that. That's my understanding. Can the NPTEL people just chat and answer that? This question, will videos be beyond the conclusion of PAE exam, which is like, after the course, will the people who enroll for the courses have access to the videos? But I see people creating new playlists all the time. Some of my old students or people who have used it. So I don't think it should be very hard. And this is on Creative Commons, right? In the sense that it's not proprietary. You can create playlists without changing it. I'm not sure there's any bar on that. We don't have negative marking. We don't have negative marking. We just want you to clear the exam. As I said, though it mimics the patent agent exam, it mimics it without the disadvantages. We don't have negative marking. Yeah. Okay. Anything else? So we will then conclude this session, and we will hopefully, if you have any questions, please raise them in the forum. And if you have any particular questions for me, you can follow me on LinkedIn. I'm there on LinkedIn with a DM, and you have to mention the background. I'll try my best to answer those questions for you. Yeah, if it is something related to some career advice or whatever, I'll try my best. There's quite a lot happening there. So if it is generally, if something that can be answered in a open session, I'll be more than happy to do that. Otherwise, we will catch up hopefully if there is another session, we will catch up in the next session, or please feel free to use the forum extensively. And if there is any particular question for us, please raise them on the forum. We'll be more than happy to answer that. Okay. Shall we conclude this session? The NPTEL team? Is there anything?
Yes, sir, we can close.
Yeah. Thank you so much.
Thank you.
Thank you very much, everyone, for joining us. Thank you. Bye-bye.
Thank you, sir.
Thank you, sir.